We made it through another weekend, everybody, so shake off those Sunday scaries, hold tight to your incredibly stylish Morning Report coffee mug, and let's catch up on some news, shall we? Happy Monday, everybody. I'm Brian, and this is the Morning Report on federal courts for September 8th, 2025. Double tap your screen, leave me a comment on the most interesting thing you did this weekend, and try to watch a minute or so, even if you're coming back later, gets us into the FYP. And if you don't have an incredibly stylish Morning Report coffee mug, you can find one at brianodc.com or the link in my bio. All right, everybody strapped in? Let's get moving. We are going to start with Haitian-Americans United v. Trump. Now, this is another TPS case, also known as temporary protected status. We talked about this last week. It's where people from a particular place are given sort of a free pass for about 6 to 18 months to let things calm down back home before we start processing their immigration cases again. And we do this if something really bad is going on there, like a coup, tsunami, Sharknado, whatever. And last week, a final decision came through on a Venezuelan TPS case that blocked the Trump administration from revoking TPS status for Venezuelans before the 18 months were up, because the statute was designed by Congress to provide some stability and a stable timetable for the people it covered, and was specifically created so that the president couldn't change the timetable. And here we have another TPS case, TPS report, on essentially the same issue, just a different country. This time, it's Haiti. But even though they just lost a case on the exact same grounds, on Friday, the administration went ahead and filed a motion to dismiss this one anyway, essentially arguing the same thing it argued in the other case. If the president can grant stability periods, then the president should be able to remove them. So we'll have to see how this court responds. In the other case, National TPS Alliance v. Trump, it was all the way on the other end of the country. This is in Massachusetts in the First Circuit. The other case was in the Ninth Circuit in California. But the cases are so similar. Now, trying to categorize a circuit based on its reputation is a losing game. But this is like lawyer football, so let's talk quarterbacks for a second. The Ninth Circuit sees most of the immigration cases in the country and has most of the case law on immigration, so it's kind of known for its immigration law. If I had to make a wildly inaccurate dart throw, I'd say the First Circuit can be a little bit less forgiving on immigration issues, particularly asylum, than the Ninth, but they've also been pushing back against federal overreach a lot lately. The lower courts on TPS Alliance seemed pretty confident in its interpretation. Armchair quarterbacking, probably better to just wait for the outcome. Incidentally, speaking of the TPS Alliance case and the Ninth Circuit, the government has filed a motion for a stay pending appeal in that case, so we'll see how that sits with the Ninth. They'll have to show a strong likelihood of success in their appeal to get a stay, as well as minimal damage to the plaintiff. And since this law specifically reduces damage to the plaintiff, they are sort of swimming upstream. All right, next we are going to look at Orr v. Trump. Now, this is a case about a Trump policy that required new passports to reflect the applicant's sex assigned at birth. Now, this is a policy enacted by the State Department in response to an executive order. But if you haven't noticed, the executive orders have been written to be intentionally a little bit vague, so they don't risk being overturned by the Supreme Court. So most of them, if you look closely, don't really say anything at all, and that's intentional. Now, the exact wording on this one is that the State Department should, quote, implement changes to require passports to accurately reflect the holder's sex. Accurately reflect. Okay. Which the State Department says left them no choice but to change this policy. And so they've appealed a lower court preliminary injunction and asked for a stay pending that appeal. One of the main questions here is whether or not they violated the Administrative Procedures Act, which lays out the process that agencies have to follow to change their rules. The State Department says they didn't violate the APA because this was an order directly from the president, so they didn't change any rules at all. He did. But the district court disagreed, and the lawyers for the president didn't really argue because they don't want this EO to be the source of the change either. That puts the president right in front of the Supreme Court where he does not want to be. So the Court of Appeals took a look here and said, nah. First, the EO was a little vague. Even the president's lawyers seemed to think so. The State Department had to interpret for themselves a bit, so they should have followed the APA when they did. Also, just because it comes from an executive order doesn't mean it gets to skip the APA either. Nice try. So the stay is denied, but it still has to go to the Court of Appeals for a real hearing, and this is only the preliminary injunction. The actual case hasn't even been heard yet, so we're still in preseason here. All right, next we're going to check back in with Make the Road New York v. Noem, because there was a filing on Friday that brought something up that I think is worth hearing. So Make the Road New York is a case about expedited removal, which is kind of a shortened version of due process that we allow when a non-citizen is stopped at the border. We just sort of let the immigration officer make a decision, and if the answer is no, they turn them around, bye-bye. But you can only justify this when it's right at the border. Now, the Trump administration has been using this deep inside of the United States, which the court decided last week is not allowed. But there's been an appeal, and the administration has asked the courts to stay the lower court decision while the appeal plays out. And their argument is that under Casa v. Trump, that case decided earlier this summer about so-called universal injunctions and how they're only allowed to protect the plaintiffs in a case. Well, here the injunction protects everyone in the country, not just the plaintiffs. So why not? Why not have it just protect the plaintiffs? Well, the plaintiffs in this case are the clientele of this nonprofit. Well, can't the nonprofit just hand a list of names and addresses of the immigrants that it serves over to ICE? Oh, right. Okay, point taken. But the issue isn't just practical, it's also constitutional. The court cited NAACP v. Alabama. It's a 1958 case where the court required the NAACP to turn over a list of its members to the state government in order to get relief, and the Supreme Court said no. The court is not allowed to condition the assertion of due process rights on the relinquishment of another constitutional right. In this case, a combination of First Amendment rights of association, privacy rights, take your pick. But this specifically, requiring an organization to turn over a list of its members, is not allowed, especially not as a prerequisite for getting a constitutional right that the court has already guaranteed them. And the government's only recommendation, other than just blocking this law entirely, was to turn over a list. And since that's all they've offered, that was a no. The court said no to the stay. So for now, the expedited removal issue is off the table. Okay. Last thing, I said I wasn't going to talk about this case anymore, but it's not going to go away. So here is a rundown on the current state of the double case of Global Health Council v. Trump and AIDS Vaccine Advocates v. Trump, which a bunch of stuff happened here over the past 2 weeks. So much I could not keep track, but I think I got a handle on it. The district court held that the government had violated the Constitution here. And the Court of Appeals reversed because the plaintiffs weren't allowed to bring a constitutional claim. They didn't have standing to bring the claim on a constitutional question or on this constitutional question or something like that. But then all of these filings kept happening. I couldn't quite make heads or tails of them, particularly because the district court kept insisting the government was still required to keep making payments, which made zero sense if the case was dismissed. But I think I got it now. Okay, it appears that the Court of Appeals said no to the constitutional claim, but the plaintiffs could bring the same claim under a different law. So we are back to our friend, the Administrative Procedures Act. You might as well get really familiar with that name. It's going to come up a lot. Basically, the government didn't violate the Constitution. They violated the APA. Okay, and so the plaintiffs filed an amended complaint using that argument instead. The district court said, fine, the injunction is still in place. Government still has to keep paying. That's that. And so that's where we are now. It's almost like we're starting this case over again and with a new theory. And then the government requested a stay from the Court of Appeals, who said no. I think everyone is sick of hearing about this case. All right, that is your Monday morning report on the past weekend in federal courts. Again, if you could leave a comment, get this out there, I would appreciate it. Grab a mug, they're pretty cool. And help me keep this thing going. I really could use your support. Otherwise, keep watching and I will keep going. Thanks a lot, everybody, and have a wonderful week.